Please be seated. Okay. All right, we're here for, oh good heavens, what are we here for? They put all this stuff up here for me. There we are. All right, we're here for oral argument on 9W Halo versus ADOR. A few things before we get started. First, we actually have students here from, and I bet I know where you're sitting back there, from Phoenix Country Day School visiting to observe. You couldn't pick something more interesting than tax exemptions. So I congratulate you on your choice, and your teacher, Dr. Colin Reynolds. Thank you so much for coming. It's important that people come and see the operation of the court, what goes on. So both counsel, your experience, you know that you each have 20 minutes, and just so everybody knows, there's a podium clock for that purpose so they can keep track, and we have the same thing up here so we know exactly how much time they have left. Mr. Cooper, I assume you're arguing. You'll have to keep whatever time you wish for rebuttal for yourself. With that, please begin.
That was a please begin.
Yeah, please begin.
Yeah.
Start.
May it please the court, my name is Ben Cooper, and I represent Angelica Textile Services. This case illustrates just how difficult it can be for Arizona taxpayers and their lawyers to figure out what their tax obligations are. Angelica uses industrial scale equipment to do what ordinary dry cleaners and laundries cannot do: process new and used healthcare textiles by disinfecting them to a level needed to market and use those textiles even for the first time out of the box. The machinery and equipment exemption has a unique instruction in this case. The operation of processing, among others, is to be interpreted using ordinary meaning within this common understanding.
Mr. Cooper, may I ask you a question about that?
Right.
You know, ordinarily we have a lot of case law which says that we'll look at the language of a statute according to its ordinary meaning at the time the statute was enacted or around there. This is interesting because it's a directive by the legislature for us to consider the ordinary language of these terms in the list. Would that be, then we should be looking at today's ordinary meaning?
In this case, I don't think it makes a difference. I think
it doesn't.
The definition of processing hasn't changed from 1938 to now, but I think you have to look at ordinary meaning, and we're not fixed in a particular time. But if you took the second edition of Webster's New International that the court in Moore looked at, and you looked at the third international now, you'd see it's basically the same definition, except they leave out the word raw material from processing.
It is, and I'm sorry, I'm just asking, not so much for this case, because I don't think it matters, the definition for this case, but just when the legislature says things like that, are we ordinarily to look at language meaning today or at the time that they...
I think you have to keep an eye to both. It's not exactly, Shakespeare using words that have a completely different meaning now. I think processing hasn't changed dramatically, as the dictionary definitions indicate.
Counsel, may I ask you a question, and as part of how you opened up your remarks, why do you feel the need to distinguish the process used by Angelica's from the process used by a regular dry cleaner? I don't see anything in the statute that causes us to look at the type of business itself.
Well, I don't think one does. I agree with Your Honor. But I think it makes Angelica a very easy case. I mean, one can argue about dry cleaners and laundries and things like that. But if you look at Capital Castings, what the court said, the purpose of this exemption was to stimulate business investment in Arizona in order to improve the state's economy and increase revenue from other taxes. Well, without Angelica's processing of healthcare textiles, Arizona cannot live its dream of being a hub for healthcare and biomedical development. I mean, it's essential on an industrial level, not just on the local level. And I think that's what easily distinguishes it.
Looking at that very specific example, it strikes me that I think you have made the point that all of the definitions of processing focus on making something marketable. And in a dry cleaning situation, that would not be making something marketable, it would just be making them clean, right?
That's correct. If my dry cleaner tries to make my stuff marketable, I would say, excuse me, that's my shirt, and you're going to fail anyway. But right, it's a fundamental difference of providing a service and then putting out a product, whether it's rented or sold, that can be used by someone for a purpose.
And to be entirely clear, without the process that Angelica does, this is not a marketable product, right?
That's correct. Even if you open the box from the manufacturer, it cannot be used without being disinfected to a level. You want to know when you check into a hospital or a long-term care facility that this has been disinfected to a level. It's clean, it's free of organic pathogens, and it's safe to use.
I sure do now after this case.
Yes.
It made me feel much better about why all the textiles you see are so clean. This court, of course, has twice interpreted processing. Once in the context of a tax statute, the second time by citing a tax statute, and has indicated that it was preparing for market. The most important thing about those two cases is they either involved or gave us examples things that did not involve producing a new product. Repacking fruits and vegetables, it's the fruit and vegetable before, it's the fruit and vegetable afterwards. In Bruce Church, this court said it was processing to vacuum cool lettuce, even though nothing happens to the lettuce. Lettuce, of course, is one of the rare vegetables that nothing ever happens to. It's served raw. It's raw when it comes out of the field, and it's raw when it's served on your plate at a restaurant.
Counsel, may I make an observation on that point you just made? Because we're looking at the statute. There are four things that have to be present for there to be an exemption. It has to be tangible personal property. We're looking at machinery and equipment. It has to be used directly, and then it has to be one of several express operations. So the Bruce Church case, trying to figure out whether or not people are agricultural workers. I don't think that business was going to seek to get an exemption for the employees as machinery and equipment.
Correct, but first you look at the court's reasoning. Second, look what the court cited for the understanding of processing. It cites, for example, Reeves, which is the Kentucky case that involves pasteurization of milk. So in figuring out processing, regardless of and it cites a patent case. So regardless of what context you're using, everyone comes back to the same understanding of the common meaning of processing, which is preparing something for market.
Right, and I guess my point simply being that ultimately, in order for a business to qualify for an exemption, you've got to satisfy four different criteria.
Right.
And it seems to me that in this particular case, with the authority that's been cited, everything wants to emphasize the operation itself, and that's just one feature. It's not the whole thing.
Right. But the other aspects, whether it's tangible personal property not in dispute, whether it's directly used in an operation not in dispute. The only question is whether we qualify as an operation of processing. And in fact, the tax court and the Court of Appeals both suggested that we were really engaged in processing, but they then made the analytical mistake of saying, but you're not engaged in the business of processing. But that's a wrong focus, because nothing about the statute talks about the business you're engaged in. It talks about the operations you're engaged in which the machinery is directly used. And that could be any number of different kinds of businesses. So for example, you can have a manufacturing business that engages various kinds of, that sell at retail, but they engage in manufacturing, or fabricating, or processing. Job printers, it's the rare case where there actually is a classification. But there's no linkage between these kinds of operations and any kind of business.
So counsel, what is the limiting principle that we should be applying? There was a concern in Blue Line, with it being overbroad. So if we're just converting one thing from one to another, technically there are a lot of different activities that could qualify as processing. How far do we go?
Well, I think processing, you have to look at it under the Duval-Ciarita capital castings, which is it's a bounded set of integrated steps that you ask. That's the operation. It's not the entire business. So, for example, Angelica did not seek to claim a credit for delivery trucks or uniforms for delivery people. It only focused on the machinery equipment that was purchased for use in the treatment of healthcare textiles to make them marketable. So it's not the business as a whole. Blue Line, I believe, was regardless of whether the result was right, the reasoning was incorrect because it asked, what's the business as a whole? As if, a business that sells pizza couldn't be involved in processing. It could. If you are DiGiorno and you're mass producing on an industrial level frozen pizzas to ship out, I think that people would call that processed food. It's processing. It might be different if the operation in your local Little Caesars is different.
But scale doesn't really factor in, does it?
Scale may, in fact, factor into it because it depends what the operation is. If, I think there are lines one could draw, for example, in food service, that, in a restaurant that divide, industrial scale, economic development oriented use of equipment in that operation from making anchovy mushroom pizzas for discerning customers.
I wish you would stop using that example. That sounds disgusting.
It happens to be my preference.
Oh, is it really? I'm sorry.
Which makes me very popular with pizzeria owners from Italy, but not with us.
All right, well, I sense we're digressing the pizza thing, but I do have a question. So even from your answers to Justice Cruz, it kind of leads me to the word that no one's focused that much on, operations. I mean, you've used it in my mind a couple of different ways, so I'd be curious as to what is your view. On the one hand, you're saying, well, this is an operation, the pizza makers, when you're talking about to scale, but then operations can also be, a series of actions in any business that leads to, the marketable product. So what is a processing operation?
A processing operation, the definition of operation, I think, is that from Duval-Ciarita, which this court then followed in Capital Castings, which is its boundaries around, that includes those items which are essential to the operation and which make it an integrated system. So it's not everything you do in your business. It has to do with that set of integrated systems. So for Angelica, that would be, it takes soiled or new healthcare textiles, it disinfects them, it goes through all the processes described in the brief, washes them 12 times, heats them to 300 degrees, and then packages them in a way that they can be marketed as disinfectant level, sanitized healthcare textiles. That is the operation. The business of, delivering it to customers, of, business computers that help invoice people, that's not part of the operation that constitutes processing.
Doesn't Blue Line effectively use operation as a synonym for business?
Yes, and to that extent, it's incorrect. And I think it goes astray because it cites a 1993 regulation from the Department of Revenue that deals with manufacturing, and there's a stray phrase, manufacturing as a business includes. Well, it doesn't say processing as a business. I'm not even sure what as a business means in the context of that regulation, whether it means, you mean when I do things as a hobby, that's not manufacturing, or when I cook at home, that's not manufacturing. I literally don't understand what as business means in that regulation. So I think Blue Line got off track by taking that language. But again, that was not about even purporting to be about processing.
Mr.
It was just
Cooper?
about manufacturing. We don't purport to be a manufacturer.
In a further attempt to hone in on the definition of processing, the Court of Appeals in its mem decision in paragraph 16 kind of ascribed a definition of processing. I just want to make sure that's still what if that was correct, and if that's something, this definition is something you're comfortable with moving forward. It said, Angelica contends that the Arizona courts have defined processing as a series of actions or operations by which tangible personal property is prepared or converted into marketable form. Is that a comfortable definition for you?
I think it's
or
a comfortable definition.
Okay, you don't want to add to that, or
I think it's, I'm not sure I would say a series of operations, because then you get operations within operations. I think it's a series of steps that are taken to convert material to a form or status or condition that's prepared for market. Because that is essentially what we're doing, and that is not, as Justice Bowley pointed out, what your other kinds of businesses who might use, thought of as being doing similar things, that is laundries or dry cleaners, don't do. They don't prepare anything for market. Now, the scale, as I said before, the fact that we do 30 million pounds a year in this mass equipment makes this, I think, a very easy case.
Council, can I ask you a question about market? When we say, prepared for market,
Right.
you're not saying, prepared for, an end product for the consumer market, because that would then seem to cut out those businesses that might create components for an assembly.
Correct. It's whatever the market is
Okay.
for that particular industry. That is, and it's a couple of different things. It could be an end user. It could be a service provider like a hospital. It could be, what we've been chastised for saying that automobile manufacturers don't use raw materials. They don't. They don't mine ore. They get parts from other companies that they then assemble into automobiles. So I think that's one thing. And secondly, you can market by renting, you can market by selling. And that's why the legislature provided the same machinery equipment exemption, including for processing, both for companies that sell it are taxed in the retail classification and those that are taxed in the rental or personal property classification. That it doesn't matter what happens in the downstream transaction where you are marketing it. What matters is the operation in which you use the machine or equipment, which is essentially an internal set of bounded procedures.
We talked earlier about some of the language in Blue Line, or you were referring to some of the language as problematic. Are you asking us, do we need to expressly overrule Blue Line if we agree with your position in this case, or what do we do with it? Because it is a pizzeria dough. I mean, it's a pizzeria dough piece of equipment, or dough for pizza.
Right.
What do we do with Blue Line?
I think food preparation exists on a spectrum, from things that are clearly industrial scale, economic development oriented, preparation for marketable form, to your local pizzeria. And I think it's difficult you have to look at the facts of each case and ask, what is the nature of the operation that's being used? Is this more of a service? Is it more of a preparation for market? And I don't think I think the court should make clear that Blue Line was incorrect to the extent it equated operation with business and looked to the whole nature of the business rather than to the process, the items in which the machinery was directly used. And that it may be that some kinds of restaurants will be held to be engaged in processing, some may not. It all depends. How is the equipment used and what is the nature of the processing that goes on? I think the Blue Line is probably, Blue Line cites distinction from GB Investment that if you're producing for inventory, that's more processing than if you're creating for order, for a customer order. So that's a distinction that would be relevant, I think, one could at least look to in the restaurant capacity. I think even Blue Line realized that there are shades of gradation, fine lines for the kind of business, even if the equipment that's being used is being used in the same way. It may be being used for a different purpose. But I can't say that, there's no reason this case for the court to decide whether or not all restaurants are engaged in processing.
What do we do with I know you want to sit down, but just quickly, what do we do with the Regulation 120 that Blue Line relied on for that? At least they were talking about manufacturing as a business. Did that apply to the B1 exemption or not? Is it just wrong?
I don't know. It certainly was never tested. It was decided, it was issued before capital castings clarified what the standard for what constitutes an operation. I don't think it's in play here because that deals with manufacturing. We're not a manufacturer or a processor. So the court could leave that for another day or it could call into question whether or not that's an accurate characterization even as to manufacturing.
Thank you.
With the court's permission, I'd like to reserve my remaining 2 minutes.
Okay, Mr. Garrett or Mr. Schaefer?
Good morning, Clinton Garrett for the Department of Revenue. I'm here with my colleagues Ben Updike and Sarita Terrell, and I'd like to reserve about 2 minutes for Mr. Schaefer from the City of Phoenix. This court has said repeatedly that statutory context is always relevant to statutory interpretation. In the last brief that Angelica filed, they tell this court that looking at statutory context is, quote, off limits. I would suggest to you that it is not off limits and that it's imperative that the court start with the statute here. And when that's your starting point, we see that the term processing is grouped with terms like manufacturing, fabricating, refining, metallurgy, all of which involve doing something with raw materials and turning it into
Counsel,
something
may I
else.
interrupt you for a moment on that? Because you've just conflated all the terms and added a phrase that doesn't exist in the statute. So how do you get us there?
And by the phrase that I added, you're referring to raw materials?
Raw materials doesn't appear anywhere in the statute. And by grouping all these different terms together, we also have a canon of construction that we give each word its own meaning, and so that they're not superfluous. Because in reading through the briefs, it seems that ADOR's argument, please correct me if I'm oversimplifying this, ADOR's argument basically is that these are all just various slices of manufacturing. And so if the ultimate business itself is not a manufacturing business, then it doesn't really matter how you try to specify the individual operation. It's not going to be exempt.
Well, a couple points. I think in addition to looking at the grouping in B1, we can also look at how processing is used throughout the statute. And we see references to the processing of ingredients, components, materials, all of which is suggestive of, again, processing raw materials and turning it into a different product. But then we can go back to the Moore case, and Angelica cites the Moore case a lot, but every single time they refer to Moore, they allied the key language in Moore, which is that the essential portion of the definition of processing is to prepare raw material for market.
Where do you get that raw material at? Because I see it's in parentheses.
It isn't. It's in parentheses within the dictionary definition. And then in the next line, this court says that the essential portion of the definition is raw materials. So the court,
Can't I limit that, though, to the context of that particular case? And to be fair to you, both sides, each of these different cases are dealing with very specific facts, and they're all easily distinguishable from one another. So, what's the overarching principle we can distill from this and fairly apply it to all these different operations?
well, and I think that's an important point, Justice, because Moore was dealing with a very different statute. It wasn't even dealing with an exemption statute. It was trying to decide which of two statutes cotton ginning fell within. And the statute in Moore referred to compounding, packing, preserving, processing, or selling. So clearly, processing is going to have a different meaning within that context. And also, they rely on Bruce Church as their other primary case. And as the court knows, that was a case concerning whether agricultural employees qualify as agricultural labor. And that case involves a definition where agricultural labor is defined as handling, planting, drying, packing, packaging, processing, freezing, grading, storing, or delivering to a carrier. So again, processing is going to have a different definition in that context. Just as, it's one of these words that just has a lot of different meanings in the English language. If there were another statute regulating computing, programming, and processing, we would construe it differently in that statute. And that's why I think it's so imperative to start with the text of the statute we're actually dealing with. And then Moore sets as the foundation that raw materials are essential to the definition. And then you see across the years, Capital Castings, it wasn't analyzing processing, but it was analyzing the statute. And I think it's significant when something is so axiomatic that it's just recited. And Capital Castings says it says a number of times that the statute concerns the quote, the process of converting raw materials into finished products. The process of converting raw materials into finished products. So again, there's a recognition that we're talking about doing something with raw materials.
Let me return to a question that the Chief Justice asked. That case, of course, preceded the statute. As we look at definitions from when the statute was adopted, whether it was in the 60s or the 80s, and we also look at the contemporary meaning, because some of these things, I think, evolve. So, for example, job printing, I think, has evolved. The nature of job printing as an operation has evolved since the statute. But I noticed that whatever the case was with regard to raw materials being considered a part of processing in 1938 when Moore was decided, I just don't see it in the definitions anymore. I see the preparing for market aspect, and I do worry that if you're putting so much emphasis on the raw material aspect of this, that is a rather shaky foundation.
Well, I think I disagree, Your Honor, that raw materials isn't incorporated in the definition in modern statutes. I think that we do continue to see that, and within Arizona's case law, and I think recognizing that processing involves raw materials and seeing it as related to manufacturing are related. And the Sani case says that continuous operations in manufacturing qualify as processing. And Mr. Cooper suggested that the blue line only concerns manufacturing, but it actually discusses both manufacturing and processing. And blue line refers to cases that define manufacturing and processing as the transformation of raw materials into products. And so what I'm suggesting is that are often joined at the hip. And even if you look at the prior version of our statute here before it was renumbered, it was, I believe, verbatim identical, except that it included the heading manufacturing or processing. So I think going back to the beginning, and I believe the statute dates back to at least the 1960s, that we've seen processing and manufacturing connected. And again, I think that's consistent with the usage of the term processing throughout 51, 59. But if the court sees processing as being something somewhat broader, then I think that's when you get into the blue line type analysis, where you kind of, I think, do a reality check and say, is this business really the kind of business that the legislature was contemplating for a tax exemption? And blue line says no, as with pizzeria. Meredith says no, as to a news station. And I think the answer here would also be no when you're talking about a business that cleans linens. They clean them thoroughly. There's no question about that. But they're a cleaning business that then rents the linens. And I just don't think that can be considered a processing operation under this statute.
Well, does it, and you put your finger on it. I mean, what did the legislature intend on this? We can't possibly guess as to that. We have to really just rely on the language is really all we have here in the context, as you say. So from what you just said, it sounds like you're trying to put, manufacturing and processing kind of together, maybe two sides of the same coin of taking something and making it something new out of it. But then you get into other things like the oh gosh, I should have picked another example, metallurgical operations, which includes leaching, milling, precipitating, smelting, and refining. And I imagine that you have businesses that just do just that. You know, they're smelters; they smelt. So they might take metals and separate them, and that's all they do. They're not making anything. There's nothing. You know, they're not. Nobody's going to buy that. Well, maybe they would, but that's all they do. Is that? Do they get the exemption then under your definition?
I think they probably would. I think in most of these businesses that qualify for the exemption, manufacturing and processing or manufacturing, one of the other operations are going to be closely related. But certainly, I think it's plausible that you could have a business that only does one specific stage of some preparation.
They smelt, exactly. So if that's so, then take that into the next hypothetical context, which is a recycling plant. Recycling plants then will take like old beat up cars and they break them down, and so they might use in a smelting operation to separate the valuable metals from stuff that's not valuable in order for it to be reused. So now they're in the business of recycling. They're not in the business of smelting, but they smelt as part of it. Do they get the equipment that they purchased for the smelter? Does that get the exemption?
I think it probably would. You're taking raw materials, the recycled items, and doing something with them to make them reusable in the future.
So why isn't that apply then to taking soiled linens that are cannot be used because they have bacteria, et cetera, that we all wouldn't want doctors and nurses wearing, and to make them usable? Essentially, they're recycling through a chemical process that makes them usable. So give me the distinction between that and my smelting example, because you say that that's not exempt. So why not? What's the difference?
Your Honor, I just think cleaning is different, even thorough cleaning. I think that Angelica is much more like a car rental company that rents out its car and then gets the car back and cleans the car and puts air in the tires and does maintenance. Much more like that than it is, say, a Tesla that unquestionably is an auto manufacturer. And then Tesla, sure, might lease cars as part of its business, but Tesla isn't making a new car every time a rented car is returned.
But is the distinction, and I'm just searching for a distinction to kind of limiting principle that we've all been asking about, is the distinction that, or is there a distinction in the fact that you can drive a dirty car, you can rent a dirty car, it works, might not be a great business plan, but you can. You can't apparently use these linens because they're unusable until they go through this process. Does that make a difference?
No, and that's what that gets to the marketability argument. And that basically leaves us without any limiting principle at all. If the question is, are you doing something to make a product available for the market, and do you refer to what you do as processing? That doesn't lead the court to an ordinary meaning. That leads the court to an idiosyncratic meaning that's basically processing is whatever a given business says it is, as long as it's putting something on the market. And that's why I think it's so crucial, and that it's supported by statutory context and historical authority to have the raw materials element here. Because if you start with that, then I think most of these cases become a lot easier. And then maybe you do kind of a blue line type analysis on the close calls. But I think starting with raw materials just clarifies
Let me ask you
a lot of
question
this.
along that, because it seems to me from reading your briefing that one of the issues that ADOR has with the business of Angelicas is that they lease the textiles afterwards. If they didn't lease, if all they were was a laundering facility where other businesses brought soiled textiles to clean for use in the healthcare industry, would that then be a processing operation? Because their business would entirely entail what is a rather extensively, according to the materials we have in the record, an extensive process.
No, I don't think that would change anything. And at least in my mind, I think the significance of leasing has been misconstrued. The way I think about the leasing aspect of the business is that I start with the proposition that processing requires a conversion of raw materials into a different product.
So raw materials then really is the linchpin for how you're analyzing.
Yeah, and then if you start there, then I think you can think about the leasing